about 70 to 80 in the meeting.
Right.
And I
Okay.
can see your slides now. And then I know the practices, I'm sure, would welcome an opportunity to have any questions, but I'll leave that to you. But thank you to Marsha Thompson, who's a partner at Capsticks, and Maddie Lawrence, Senior Associate at Capsticks, who are going to be delivering a session on employment law for us and answer any questions at the end. So without further ado, I'll hand over to you, Maddie. Thank you.
Thank you. Can I just double check that you can just see the slides and nothing else?
Yeah, we can. Just
Thank
the slides.
you. Okay, perfect. Right, okay. There we go, Marsha.
Fab. Okay, so just morning from me. My name's Marsha Thompson, as Lucy said. I am one of the partners in the employment team at Capsticks Solicitors. We are based nationally, both in Birmingham, Leeds, London, Winchester and Manchester. A bit about me, I have been working in employment law for about 16 years, almost 17 years now actually, and I've been at Capsticks for 7 years, and I lead on our primary care work for employment law, and I'm joined by my colleague Maddie, who also helps me to lead on work primarily for our GPs and dentists. Maddie, do you want to give a quick intro to yourself?
Yeah, I'm a senior associate. I've been at Capsticks nearly 4 years now, and I've been working in employment law since about 2018, working closely with Marsha on GP and dental practices as well.
Perfect. Right, so what we're going to do today is we're going to cover the areas set out on the slide, but primarily really just have a think about what practices need to be looking at for when these provisions do come in. So the main crux of this is going to be around the Employment Rights Bill and the impact that potentially could have on other sectors in addition to sort of healthcare. So we primarily work for the healthcare space. The majority of our clients are NHS, but we do have a practice, like I said, with GPs and private healthcare. So it's going to have a knock-on effect across the board. But for the purposes of today, we just want to really focus on things that the GP practices need to have a look at and think about. Luckily, there isn't anything to do today, but there is going to be lots to think about over the next year, 18 months or so. So as I've said, Employment Rights Bill, statutory neonatal care leave. We're going to be looking at sort of the general impact on primary care and your workforce as a whole, some of the legal challenges that you might be looking for, and a short slot on physician associates that we have been looking at into a bit more detail. We've just recently done an article on that, which is going out shortly, on some of the issues to have a think about. I'm not sure if any of your practices are affected by this issue, but if you are, then give us a shout. Okay, so next slide, please, Maddie. I think that's you.
Yeah, so I'm going to come on to the Employment Rights Bill. So first of all, what we'll have a look at is what has the bill actually delivered. So it has been laid within 100 days as promised. It's delivered a framework for change of employment rights. If it is passed in its current form, it will be transformative. Whether it will be passed in its current form is another matter which we'll look onto. I mean, it was only laid in October 2024, and since then it has changed quite a bit. There's been some bits added, some bits removed, which we'll come on to. But generally, in the grand scheme of things, it will be transformative for most of the changes that it looks to make. There's the delivery of the key legislative reforms set out in the plan to make work pay, which we'll come on to later. It will update and enhance existing employment rights, provide for new rights as well, provide for pay and conditions in particular sectors, reform trade union matters and industrial action, and set out a new regime for the enforcement of employment law. How and when will the bill deliver it? How will the changes affect employment? That isn't yet clear. The detail will be determined in 2025 following further consultations and in further legislation, which is probably going to be into the second half of the year. Well, definitely will be into the second half of the year. When will it actually become law? Well, little will change before 2026. The bill is expected to be passed by July 2025, but nothing is certain, and that was initially April 2025, and it's been pushed back already. It is very big, and there are a lot of changes that need to be worked through before that can be set out in certain. But the only thing that will come into force on that day is the repeal of minimum service level legislation. Changes to some of the trade union rules will come into force 2 months later in September, and the rest is not before 2026. And day one, unfair dismissal rights, which again we'll come on to in a little bit, will not be before autumn 2026. So as Marsha was saying, there's quite a long time until it will actually become law, but you see little bits coming into force, trickling in from about July onwards. So if we have a look at the bill's progress so far, as I said earlier, it was laid before Parliament in October 2024. It then went to a committee stage where the detailed examination of the bill took place. That concluded on the 16th of January 2025. There's a link there to the Commons Library briefing if anybody wants to have a look at that. There's quite a helpful summary. We'll send through the slides afterwards. Only government amendments were accepted, including a new clause to the extension of tribunal time limits from 3 to 6 months, which again we'll come on to in a little bit. The bill increased from 158 pages to 199. There's again a link there to the version, so it is very big. There's quite a lot in there. After that, it returns to the House of Commons for the report stage, where the amended bill can be debated and further amendments proposed. On the 3rd of March 2025, the Business and Trade Committee published a report which set out 21 conclusions and recommendations to strengthen the measures in the bill and effectiveness. Again, we've put a link there if anybody fancies looking at that. So there's been quite a lot that's happened in March. On the 4th of March 2025, the government published responses to the 5 consultations on its proposals for statutory sick pay SSP for low earners, modernising industrial relations, extending zero and low hours protection to agency workers, remedies in file and rehire and collective consultation cases, and tackling non-compliance in the umbrella company market. And again, we'll come on to most of those in a little bit. On the 5th of March, the government published a 215-page amendment paper, which again, there's a lovely link there if anybody fancies reading that. On the 11th and 12th of March, there was the report stage and third reading, and the bill with all the government amendments added into it was passed by the House of Commons with a majority of 233. The latest version of the bill has now gone to the House of Lords, and there was a second reading late last week, so we need to keep an eye out for what's happened there and for any further updates to be published. Marsha? This is just quite a helpful summary of the bill. I won't go out into detail, but that essentially sets out what the parts are, parts 1 to 6, and a summary of where they're located, so that if you do ever need to look through the bill, that's where certain parts will come up when you need to look at it. And again, that'll be in the slides when we send it over if you want to have a look at it.
Thanks, Maddie. So yeah, that's just sort of, it sets it out into different sections, doesn't it, in terms of what bits to look at for where. Quite helpful, because it is it's going to be a huge piece of legislation when it does finally come out. So in terms of the overall impact of the bill, I think the idea is, or the intention really was, to set out a set of regulations that are basically going to improve the health and well-being of our staff and our workforce. So looking at their rights and improving those rights, that they can then feel confident enough to challenge where there are issues within the workplace. But at the same time, the idea is to try and improve productivity and retention of workers within the workforce. As we know, especially in the NHS, retention can be an issue, especially in this post-COVID period that we have right now. We do see a lot of tribunal cases coming through where people are just really disgruntled, people are unhappy, people are not, feeling overworked and underpaid, basically. So it's really about just trying to improve the situation for them, so that we can, increase productivity, but also increase job satisfaction and retention. However, it's really important to look at the cost of this. They say it's going to take around £5 billion as an additional cost to implement once once these changes come into force. So obviously that cost to the employer in the round. How are we going to offset that? What your practice is doing to have a think about how we're going to implement the changes that are needed. Some people may need additional HR resource. Some people may need external resources, or you may need to think about what you're doing in-house, who's going to do what. We do think there's going to be an increase in ET claims. In fact, I've had a couple of ET claims recently from GP staff members, not necessarily in relation to the Employment Rights Bill, but it just shows that there is kind of more of a feeling towards litigation, whereas there probably wasn't a few years ago. And of course, there's going to be increased industrial activity. Next slide, please, Maddie.
Thank you. Yeah. So the sorry, was somebody speaking then? Okay. It must have just been my computer playing up. So
sorry, Maddie, to cut you. I forgot to say, if you do have any questions, then feel free to just drop them in the chat box if you feel there's a burning issue you wanted to ask. If we can't get to it, we'll try and get to it when we're speaking. If we don't, we can sort of take it offline, but happy to answer. I'll be fielding it in the meantime whilst Maddie's speaking, and vice versa, if you do have anything you want to ask. Sorry, go ahead.
Yeah, thank you. So one of the main impacts of the key reforms is the removal of the 2-year qualifying period for unfair dismissal. So at the moment, you need to have 2 years continuous employment service to be able to pursue a claim of unfair dismissal or constructive unfair dismissal, and that will be removed, and essentially you will be able to pursue a claim from day one. And what that is bringing in instead is an introduction of a statutory initial period of employment, during which employers need only to carry out a proportionate assessment of an employee's suitability for the role. So as it stands, I think that is going to be about 9 months. So in that 9-month period, the employer should essentially have a really robust, strong probationary period, and will need to be really on the ball throughout that probationary period to assess the employee's suitability. And if they aren't suitable for the role, then the dismissal can take place. Compensation for that is to be determined, and that's still to be consulted on in the bill, but it will be a little bit different to compensation for an ordinary unfair dismissal beyond the 2-year point, as it stands at the moment. And it will obviously be much less if there was to be an unfair dismissal during that period. So the impact of this and action points to think about. Will it replace probationary period? Well, it will be a probation, kind of, yes, it will be a probationary period. It is kind of the same. It just means that employers need to be really robust, have a look at the probationary periods. Are they working? Are you looking at an employee's suitability in that time? Are you having regular meetings, one-to-ones, understanding if that works? And that's something that you'll need to have a look at in the contracts and in the policies as well, and make sure that they're up to date and amended, and thinking about whether that will impact locums and fixed term contracts as well, because the non-renewal of a fixed term contract will be a dismissal, and it obviously will now come under, as it stands, if there was just a year-long fixed term contract, for example, you could end that quite safely, whereas that won't be in place anymore because there will be the removal of the 2-year qualifying period. And just to say as well, I can only see the chat messages when they pop up at the side, and I can't see them all because my screen is just saying the slides. So if I do miss anything, then I'll have to come back to it at the end once I close my slides off. Okay, so go on to the next slide. The second impact of the key reforms will be a new right for 0 and low hours staff to be offered a guaranteed hours contract at the end of a set reference period, and to be given reasonable notice of any changes in shifts or working times, with compensation where shifts are cancelled. So compensation for that, if shifts are cancelled, the tribunal has set that it will be just and equitable in the circumstances based on the financial loss of the employee, but the employee worker has a duty to mitigate any loss. And the compensation will be subject to a statutory maximum, which will be a set number of weeks' pay, as the Secretary of State may specify in regulations. So that all sounds very vague, and that's because it is. Essentially, the detail is still to be consulted on. We don't know what will be just and equitable, what the compensation will be, what the reference periods will be, what makes a guaranteed hours offer, essentially anything. We don't know what any of this will be at the moment, so we still need to wait for that to be consulted on and to come out indefinitely. What did change in March 2025 though is that initially this was only going to apply to 0 and low hours staff, whereas now the bill has closed the loophole, meaning that it will also apply to agency staff as well. So this now you need to think about whether you have 0 and low hours staff that will be impacted, but also whether there will be agency workers that will be impacted as well. And we've got some figures there at the bottom where 14.7% of 0 and low hours workers are in healthcare, and now that that's agency workers as well, it will probably include quite a lot more, and the figures will be much higher. So you need to have a look at the operation of any locum and casual work arrangements. The good news is, though, that there is now a provision to contract out of the rights entirely under the collective agreement. I know that when we met last time, there were some questions in the chat box where there were people who maybe had retired and come back to work on a 0-hour contract, and it worked for them. They just picked up a few shifts as and when, and they were happy doing that. And the consultations now say that you can actually contract out of it, so you don't have to follow this if both sides are happy to do that. So impact, again, as I've just picked up previously, it might impact quite a lot of staff. So just start having to think about who will be impacted by this. Will they want to contract out of it? If not, what will you need to put in place? How will you need to amend your policies? How will you ensure that there are robust arrangements in place for cancelling shifts? There's a quote there on the side which describes this legislation as fiendishly complex, which it will be when it does come into place. There will be quite a lot to think about, so just keep a lookout about what those definitions are once they do come into the legislation, and think about, will it mean that you need to have more substantive staff on rather than employing 0 and low hours staff as well?
Maddie, can I just go back a slide? Sorry, just talking about the probationary period. There's just a question in the chat there from Ruth, and I know Marsha has answered some of it, but just saying about with probationary periods, sorry, I put my teeth in. With probationary periods, we are able to extend if required. For example, if someone has had a disproportionate amount of leave in the probation window, will it be the case that the 9 months will be fixed in all circumstances? So I guess that forewarned is forearmed, isn't it? So it feels like these changes are a long way away, but that's quite a big one, isn't it, in terms of going from 2 years to 9 months? So definitely something that we all need to be aware of in general practice. Just the question about, will it be the case that the 9 months will be fixed in all circumstances? If you've got any advice there.
Yeah, I don't think so. I mean, essentially, you can still have a probationary period and you can still extend it if it gets to the end of that 9 months or whatever length of time the probationary period is, and you feel the need to extend that to continue to understand the suitability to somebody's role. That probationary period can still be extended. It just means that if they are dismissed after that, if that isn't for a fair reason, potentially then there could still be an unfair dismissal there. So you just need to really make sure that if you are extending probationary periods, or as you're going through, that you are on the ball, you're having meetings, you're making notes of those meetings, you're documenting why that person might not be suitable for that role and why the probationary period has been extended, why the employment has been terminated.
Yeah, thank you. I think that's kind of key with everything, isn't it? Sorry, Marsha, I was just saying about how, like we always say in the LMC, data wins arguments and fact, not fiction. 100%. So document everything, the conversations that you're having, put them in writing, so that you've got that should it need to come to it, because you can't rely on the kind of, we had this conversation and this is what was agreed, and people's interpretations. That's a really key learning point, I think, isn't it, about documenting everything.
Yeah, the other thing I was going to add was, completely agree. One of our key issues at the moment, or concerns, is disclosure in tribunals. We have lots of issues about what people can disclose, what they've got written, and the tribunal will come down heavily on people who cannot evidence what they've decided. So we've decided this, but who discussed this, whatever. The other point I was going to make was about consistency of approach. Be really careful when you are carrying out these probation processes that you are consistent across the board, because you've got to think about as well people who may have protected characteristics, So they could have a potential discrimination claim aside from any unfair dismissal claim if you've done something in one case for one person and there was a very similar scenario in another case, and they find out about it, whatever, they could have a cause of action. Say, for example, you've got 3 people who are both going through a process. One's disabled, one's not disabled, one's black, whatever. Is there a consistent approach subject to any reasonable adjustments that we're following? That's another thing just to flag in the
No,
background.
it's helpful. Thank you.
Sorry,
So
Maddie.
having your policies and processes written down and following them.
Yeah.
Exactly.
Yeah. Okay. Onto the third slide then. So the impact of the Aquila forms will in relation to flexible working. This kind of hasn't changed. Essentially now it's that there is a right to request flexible working from day one, and what it says is that the request can only be refused if the refusal is on a set ground, which are the 8 set out there. On the slide, I won't read those out, but that's the same 8 that's been in place for some time. And it may be added to in regulations again, so there might be some more points added there. And if it does, then look out for any updates on that. Capsticks will send out some insights, which we've got links to later on. And the request can only be refused if it's on one of those set grounds and the refusal can be shown to be reasonable. And there is also an obligation to notify of the refusal and reasons as well. So again, coming back to what we've just been talking about, if anybody does make a flexible working request, just make sure that you document the refusal and the reasons in a letter to them, but also document any discussions, investigations, etc., that have taken place to look at the reasons and why that has been refused. So, for example, if you're looking at a burden of additional costs, what did you look at to come to that decision? Can you document it just in case there is a tribunal claim brought? Then you've got the clear evidence there that can be disclosed and relied on for the tribunal.
And is that from what's the current time? Is it still 6 months for flexible working? Because I feel like I've seen something about changing from day one, but I don't know where I've seen that.
I think off the top of my head, Marsha, tell me if I'm wrong, is it 26 weeks you've got to have for flexible working? Whereas now it's a day one, right?
So it is day one, okay.
Yeah. So the impact of that, I guess there'll be more people who might be making applications, but the impact is potentially limited depending on the contractual arrangements in place, because you can still refuse it. You just need to make sure that the reason for that is reasonable and that you've got clear evidence to demonstrate those reasons as well. And you might need to update any policies and procedures regarding flexible working requests as well. Okay, I'll let Marsha go on to the trade union. Trade unions.
Thank you, Maddie. So yes, just a quick sort of update on trade union rights. Just so you're aware, really, if they're, I don't know to what extent might be impacted, but just so you know, in terms of the key reforms on this issue, then one of the main things is that you only need to give 7 days notice of industrial action that's due to be taken amongst staff. There's also going to be the abolition of the 50% turnout threshold. So essentially what they're saying is you only need a simple majority of those voting in the ballot to be able to call members to take part in industrial action. Other things that they're looking at are allowing people to do electronic balloting rather than sort of in-person physical paper balloting. There's also going to be a new provision for members to be able to access the premises and have time off for their union, specifically for their union duties. You'll note, I don't know if you were aware of the minimum service level provisions, but that's now been repealed. We spent hours and weeks and months drafting that legislation, interestingly, and now it's going to be repealed. So there will no longer be a requirement to have a minimum service level in times of industrial action. Again, one other thing to sort of be aware of is that union members will be protected from suffering any kind of detriment short of dismissal if they take part in industrial action. So, for example, if one of the staff members decided they were going to strike, they then got disciplined, or they then had issues raised against them following on from that, and they say that they suffered a detriment, that could potentially be a course of action. So in terms of what we need to think about. It's really thinking about the staff that are members of unions and whether or not this could impact on the practice. It's now going to be, the impact of this really is that it's going to be easier for people to take action, strike action, essentially is what this is going to mean. Again, a lot of this boils down to, what does your provision say? What do your policies say about union activities, union duties? What do your contracts say, if at all, if applicable? But essentially just having to think about the fact that now, when this comes in, it will be easier for people to strike, and it will be protected for them to not be suffering a detriment as a result of that. So employers need to have to think about how they're responding to staff that are going on strike. Next slide, please, Maddie. So in terms of the rights that trade union members have, following this consultation that happened this month, there were various amendments that they were suggesting to the bill. And again, this includes this issue around the digital aspect of accessing ballots, extending the mandate period from 6 months to 12 months, and then giving 10 days notice rather than 7 days notice. So the first set was mooted at 7. Recently, they've then come back and said, okay, well, 10 days notice seems reasonable. And then further restrictions on unfair practices in the process that may take place. After the bill is passed, though, there are some plans to further consult. So we've just had a whole raft of consultations, but there's going to be further consultation. And potentially, I think someone's off mute, are they?
Yeah, Marsha, I was just going to say, sorry could everyone who's just listening in just please remember to go on mute, please? Thanks.
So yeah, further consultation on modernising the TU landscape. So essentially what they're just trying to say is they're going to try and digitise a lot of it. They're going to modernise a lot of it. But again, TBC, but we've just picked out a couple of the key things that are relevant. Next slide, on to sexual harassment. So in terms of sexual harassment, there's going to be, the main change is that there's going to be a higher threshold for what that means, basically. And the bill states what steps are deemed reasonable for an employer to have taken will depend on the circumstances of the case. However, an employer will have to take all reasonable steps if there are no further steps that they could have reasonably been expected to take. So essentially, you have to take all steps, all reasonable steps, to prevent harassment from occurring in the workplace, or sexual harassment from occurring in the workplace. And employers will be liable for acts of third parties. So someone who's a third party to your practice or your organisation who commits sexual harassment on the grounds of a protected characteristic. So that could be, if it could be sexual harassment, or it could even be harassment on the grounds of another characteristic. Unless you've taken all reasonable steps to prevent that, you could be liable for a discrimination claim, for a harassment claim. So it just kind of widens the pool, really, of people who could be liable. And really, for the employer, it increases risk. So again, really thinking about who you have coming on your premises, whether they need to be there, what your policies say about people visiting the premises. Are you taking reasonable steps? And again, document what you have done to ensure. So what training have you rolled out across the organisation? Things like that. What do your policies say about it? Are there any other risks to identify around people that are third parties? Do you need to have any kind of indemnity clause in your contracts or your agreements? If you've got contractors coming in, do you need to have something that says, we indemnify, or they indemnify against any sort of such causes of action? And then the other thing to mention is that the bill states that disclosures relating to sexual harassment will now be protected disclosures for the purposes of whistleblowing. And what that means is, currently, in order to bring a claim for detriment following a whistleblowing claim, you need to be able to say, one, that you have made a disclosure which is protected and qualifying to the relevant person, and then you need to say, two, that you've suffered a detriment as a result of making that disclosure. Here, what the Act is saying is that if you make a disclosure, if you make a complaint about sexual harassment, and you then suffer a detriment from your employer, you could then, that's automatically seen as a protected disclosure. So you could have a cause of, or one of your staff could have a cause of action for whistleblowing. But it's just to really ensure that workers will speak up about sexual harassment, and to know that they'll be protected against unfair dismissal or detriment following that disclosure. So that's quite a key issue.
Asha, could I just ask a question, please? Would that be okay? There's just, thank you. It's just a few in the chat, and Debbie was thinking the same as me. So obviously, you were saying about the key reform changes and the fact that third parties will now include patients, and thinking about kind of quote unquote inappropriate behavior from patients and how we protect our employees. Could we talk that through in terms of what you would deem to be reasonable, and what you think as an employer they should do as the sort of gold standard to protect themselves against any potential claim? So there's a question in here from one of the GPs about a patient that persistently calls somebody love. And there's just one more question just on that, just saying what sort of steps are deemed reasonable for an employer to have taken. So I guess if you're looking at a case, what would you expect to see an employer's done? I think that would be helpful, because as you were talking, I just thought, oh, patience, that's how do we control the behaviour of others? Yeah,
so the thing to remember is it's about liability. So one of your patients, or anyone really, your staff, could say that they have suffered harassment from a third party at your practice. So someone's harassed them. That could be a contractor coming in, like you said. It could be a patient harassing the receptionist, etc. But in order to bring employment tribunal claims, obviously the person would have to be within the remit of the employment tribunal. So it would have to be one of your staff members, or even one of your, if you've got like agency workers or whatever, they could potentially say that they are eligible to bring a claim. Now, the issue is around whether or not the employer is liable for third parties coming onto the premises for any harassment action that they may take. And in terms of things that you can do, I think it's just about having clear processes now. So in relation to your patients, you'll have signs, you'll have things that say, we have a no tolerance in terms of harassment, our staff will not be harassed, etc. I think you're limited in terms of controlling what your patients and visitors do, but I think you can make it really clear that
the expectations.
Exactly, you can do that, and then you can point to that in terms of saying, well, actually, we've put these signs up, we've got policies or whatever on our website, we say what we're going to do. Now, if someone did say, for example, you were saying about the person constantly calling, it depends on how the impact that has on the person that's receiving the call. So if your staff member feels like they're being intimidated, or feels like they're in a hostile environment, etc., they would then come to you and say, oh, this person is doing X, Y, Z. It's how you then deal with that as an employer responding to that. Are they going to raise a grievance? You need to address it. You need to investigate. Do you need to have a discussion with the person who is carrying that out? Because ultimately, whatever happens, the employer is going to be liable for it. So we need to make sure that we minimize the risk to that happening, that we have those conversations. It may just be a conversation with the practice manager saying, this so-and-so has said that you've called on 15 times, whatever, we'd ask you to do X, Y, Z. I'm not sure how you, in terms of banning people, have you ever got to a stage where someone has become so violent or aggressive or whatever that you've had to exclude them from the practice?
Yeah, there's processes that follow in terms of 7-day removal and instant removal for violence and abuse. But I think what I'm hearing is it's almost like each practice specific a bit in terms of their policies, and can you demonstrate that you're following all your own business policies and procedures related to harassment. Debbie, Ruth, any reflections from you at all? I can see you've got your hand up, Debbie.
Yeah, it's going to be interesting, Lucy, how the ICB or powers that be bring this in to what we can do with patients, because as we know now, patients, you have to give them warnings and things, and sometimes it's that bad. You think, you've got a criminal act, and then you can't remove a patient, who's been abusive. You have to warn them first, and you have to jump through some hoops sometimes. So it's going to be interesting how it's going to align with everything. I think, because
There's a
you
lot
know,
of thinking it through, isn't there, about how it links to your zero tolerance policy in your practice, or do we send a warning letter first, and does that follow through? Definitely lots to think about.
You've got to
Oh.
balance it as well, don't you? Against, so you've got to
Mm.
balance the patient against the patient needs against your staff's needs. But yes,
Yeah.
the key word in employment is always reasonableness. Is it reasonable to do what you've done? And someone said, would it not be reasonable to send a warning letter and then remove them? Potentially, yes, that could be reasonable. But again, it's about documenting it. How, you know, how many discussions have you had beforehand? I don't think there is a hard and fast rule, but I think again that plays into what do your policies say and what do you say you're going to do for it to escalate to the next stage. And someone else has said training up state policy. So yes, we can help with all of that if we needed to.
For example, I had a learning difficulty patient on Friday who's moderate learning difficulty, who was swearing at the staff.
Yeah.
And so I would give that person a bit more leeway, but the staff were quite unhappy with me for not giving that person leeway.
Yeah.
And, you know, some of the doctors were saying it don't matter if they're learning difficulties or not. And it just gets quite tricky then, because, you know,
I think I would
it's
say
just going to be interesting.
Yeah, I would say to that, that's really around making sure that your staff are aware around disabilities, really sort of getting, you know, training and making up to date in terms of reasonable
They
adjustments.
are, but actually the doctors were disagreeing as well, and thought it was unacceptable for this moderate LD patient to swear. And we do get into disagreements, is what I'm saying, on what one will accept and what one won't, and how sometimes how you deal with them. You know, she doesn't swear at me, for example, so it can, you know, be different in different things. So it's just going to be interesting how it all aligns, I think, if we've got our hands tied.
It will, just that, I mean, the key thing there is about the duty to make reasonable adjustments. That person there obviously has difficulties. They may have issues with communication, etc. You know, we have to give them a little bit of a wider berth, but that doesn't mean that you should expect your staff to be subjected to sort of aggression, violence, etc., abusive behaviour. And I think there needs to be lots of conversations with staff around that, maybe in your team meetings, maybe that, you know, there's discussions around what we can do as a practice to kind of mitigate that. So does it mean some, like you say, that person wasn't speaking to you in that way? Is there someone that could be involved in kind of taking the sting out of it if they're getting into an altercation with that person? Is it Ruth's got the hand up?
Yeah, hi. I suppose the thing about it as well that is sort of, I picked up on, you said that it depends on the employee as well that's raising the grievance and what they deem to be hurtful or how they feel that they're in a hostile environment, which I absolutely understand and support. But never having been a part of an employment tribunal in the NHS, I suppose my concern is, what if we have an employee with additional needs or that kind of thing, and then they're responding out of, if you're saying that you can't outline what is reasonable and it's based on their feeling, I suppose I'm struggling to understand how we can support in every situation that's like that. Obviously I want to be supportive, but you know, if we're using an example of a patient referring to you as love or something like that, if they react to that and then I have a conversation with the patient to say, please don't call somebody love, that's not going to be grounds for removal from them ever.
No.
We're never going to get to a point where I'm supported by the ICB or whatever to remove a patient for saying love. So I can't take that action, but then I'm liable against an employee who deems that as hostile or whatever it is. I suppose it's just, it feels quite grey area.
It can be. So the tribunal will look at a load of circumstances. So they'll look at the person's, say, for example, someone says they've been discriminated against or harassed because of their protected characteristics. Remember, harassment has to be in the tribunal because of a protected characteristic. So, for example, the love one, we're going to say potentially sex. We can say that that's something that people tend to say to women more than they say to men. I don't know if you agree or disagree on that, but I think to me it's like, oh, they're their love, or it could even be age, but it has to link back to the protected characteristic. So the person needs to have made that person feel intimidated, hostile, all of the definition of the Harassment Act, it needs to have made them feel like that, but linked to their protected characteristic. Now, I get what you're saying about it's not clear on how we protect against that. But if the person brought that claim, the tribunal is going to look at how that person perceived that, and they will take into account things like, do they have their own additional needs? But the intention isn't really. It's more about the effect. So the intention really isn't sort of taken into account. It's more about, okay, well, what did it actually do to that particular person? Did that person feel? I would say, in a situation where someone calls somebody love 1 or 2 times, that probably wouldn't constitute harassment, even if the person had additional needs. But I think if there may be a course of action, so for example, it was going on over months or weeks or years, and that person felt tearful about it, and they felt they're being condescending towards them, and that could potentially then. But again, it's really difficult because each case turns on its facts. The tribunal will go through the test and say, was it intimidating? Was it hostile? Did that person feel that way because of what that person said, because of their sex? So it can be quite complex. But I think for me, it's about the human element. It's about that dialogue. It's about having conversations with people, making sure that everyone's clear on what the expectation is, making sure that the staff know that we're going to protect you, we're going to back you up, but that we also have competing priorities. So the person, you were saying about the person who was called love, that could turn into a grievance. You would look into that. You would look into the grievance, get it investigated. The investigator would have to determine whether or not, on the facts and the evidence, it constituted harassment. It may not, depending on how often, etc. So sorry, long-winded way of saying the tribunal will look at the whole, all the circumstances of the case.
Thank you, but also really important to talk it through. Really helpful, I think, to bring a sort of scenario and work through that, because like Debbie and Ruth say, this is their reality of what happens in general practice, and knowing what to do. Yeah,
exactly. Okay, sorry, we're going to move on because we are running out of time, aren't we? Which is great though, because it's good to get the discussion going. I find that people tend to learn more when we get discussion. We'll send the slides through anyway if we don't get through to the end. We've only got an hour, I think. So where are we next? Is it yes, so next slide please. Dismiss and re-engagement, Maddie.
I think that's
yes, so I'll just scoot through the next couple. So the Employment Rights Bill will make dismissals and re-engagement, so what we call fire and rehire, it will make it exceptional. So you should only really be doing the fire and rehire in certain circumstances, very exceptional circumstances. Whereas right now we advise all the time on, people that want to vary their contracts. For example, they want someone to accept a different contract or to different contractual terms. We might say, right, you dismiss, rehire on the new contracts, or someone who is dismissed and is then re-engaged on a different type of contract, etc. But the idea is that the bill will reform that, and it will make it automatically unfair to dismiss an employee where they refuse to agree to your variation. So you said to them, look, I want you to take these terms. If you don't accept them, I'm going to dismiss you. It will be automatically unfair to do that. Or where they're dismissed and either the employer or another person is re-engaged on a varied contract to carry out that substantially the same duties that they carried out before they were dismissed. So if those two situations apply, it will be automatically unfair to dismiss, fire and rehire. And then they say that there will be a limited exception to this protection where the employer can show that their reason for the variation was either to eliminate, prevent, or significantly reduce or mitigate the effects of any financial difficulties that they were having at the time of the dismissal, or that were likely in the immediate future to affect the employer's ability to carry on their business. So again, it's kind of the cost element of it. If they're saying, it's cost-cutting exercise, potentially you may be able to argue that. For example, in an insolvency situation, that sort of situation might arise. And in those circumstances, the tribunal will say whether or not they felt the dismissal was fair with regard to all those specific matters, whether there was consultation, etc., etc. And then in terms of the impact of this, it's going to be quite wide-ranging across the healthcare space. As I said, we advise on our NHS trusts doing this quite frequently. It will have an impact on your organisational change, things like harmonising your terms, etc. Have a think about your policies and your regulatory requirements. And it will also give the trade unions more negotiating power as well. If you do impose changes to a contract after this, then it's more likely to be challenged as a result of the reforms to this part of the Act. And then I'll pass over to you, Maddie, for the next bit.
Yeah, thank you. So the further impact is day one rights for paternity, parental and bereavement leave. So essentially now, for paid paternity leave, you will be able to, when it comes in, take 2 weeks plus the ability to take after shared parental leave as well. And the aim of that is to enable fathers to solo parent. For unpaid parental leave, you'll be able to take up to 18 weeks unpaid leave per child, taken before their 18th birthday in blocks of up to 4 weeks per year. And for bereavement leave, there will be unpaid bereavement leave. We don't know yet how much leave will be able to be taken, when that can be taken, the definition of a bereaved person, reference to the relationship between the bereaved person and the person who's passed away. And again, all that detail is to come. But at the moment, there is only the right to bereavement leave under Jack's Law, which is 2 weeks of leave. So the impact of that will be an increased take-up. The government has assessed that this change will bring in an extra 1.5 million workers into the scope of parental leave, and an extra 2 million for bereavement leave. So that's going to be a lot more people that can take these different types of leave, paid and unpaid. So you need to have a think about how that is going to impact on staffing, whether you'll need to look at some staff to cover, and have a look at your policies as well so that they can be updated to reflect the new types of leave. In March 2025, from the report stage that was discussed, they also had a look at different types of bereavement leave and pay for pre-24-week pregnancy loss. That isn't covered at the moment, so there was discussions about what types of leave should be available for individuals who suffer the pregnancy loss pre-24 weeks. Leave for kinship care as well. There wasn't anything decided about any types of leave put in place, but they did have discussions about putting in place some legislation to define what kinship actually means, because I know that across different sectors that is defined in different ways. And then also some paid carers leave as well. Since the 6th of April 2024, unpaid carers have been able to take up to 1 week of unpaid leave per year to be used for caring responsibilities. And there was an amendment proposed that should be paid, but again, that's just something that's under review. So looking at extended protection, that's what the Employment Rights Bill wants to put in place as well, for protection from dismissal for pregnant employees and those returning to work after the period of statutory leave for new parents as well. So it's going to put in place more protection for not only ladies coming off maternity leave, but also individuals, fathers taking parental leave, etc. There will be a power to make the regulations to ban dismissals of women who are pregnant on maternity leave and during a 6-month return to work period, except in specific circumstances. So what the specific circumstances are is not yet clear, but it's probably going to mean something like gross misconduct, gross negligence, or illegality. And for those coming back from shared parental leave, adoption leave, etc., they're going to look at how they can regulate the dismissals there. So it's not going to be as strict as those coming back from maternity leave, but we just need to wait and see what comes out and when dismissals will be permitted.
Maddie, can I just ask a question? Sorry, it's always me tons of questions. The bit you mentioned about the parental leave, so not shared parental leave in terms of maternity, paternity, but you know how you can take a week. I was under the impression it's 1 week unpaid per year of the child's life up until they're 18. But did you just say something about a change to 4 weeks?
Unpaid parental leave,
Yeah,
up to 18 weeks unpaid leave in blocks of up to 4 weeks per year.
oh, 4 weeks. That was on the shared parental. So you know, there's the bit about when parents can take like a week unpaid leave as it's called something, isn't it? Sorry, I'll ask it another time. I thought I'd just misinterpreted that.
Yeah, no, I don't think I spoke about shared parental leave. It's just I talked about paid carers leave. That's a week.
Yeah, and that's paid now, isn't it?
No, that's unpaid still. They're talking about it being paid, but it isn't yet paid. And then just bereavement leave. Paternity leave is 2 weeks, and then unpaid parental leave is up to 4 weeks per year.
Thank you.
But
That
yeah,
was the bit, I
drop
think.
a separate
Yeah.
drop a separate message if there is anything else.
Thank you.
Okay, thanks, Marsha.
Right, so let's just scoot through the next few. I think we literally only have about 8 minutes left, and I want to try and get through as much as I can. So yeah, so the first thing in relation to pay bodies, so there is going to be central negotiating and pay bodies that are to be established by the new regulations for people who are working in social care work. Essentially, it just means increased terms and conditions for people, terms and conditions, and an increased cost for providers, but increased protections for those working in social care, and that pay body will deal with any issues arising from that. On to the next one, Maddie. So one thing to have a think about is in relation to collective redundancies. At present, where employers are going to be dismissing 20 or making redundant 20 or more employees at one establishment within a 90-day period, the collective redundancy obligations apply. The proposal is to remove the words any one establishment from the provisions relating to that 20 plus proposed redundancies. That's now been taken out from the wording, and that's in response to concerns raised that an unintended consequence of this is that it would leave large multi-site employers stuck in a never-ending cycle of collective consultation in respect of unrelated redundancies. And that proposed amended regulation reinstates the concept of one establishment, but then it allows, in a case, for example, where employees are being made redundant at more than one establishment, for the regulations to set the number of employees higher than 20 for the purpose of determining when collective consultation will apply in relation to those employees. So this, in terms of the impact on the practices or any organisations that are proposing that, the key thing is that collective consultations are more likely to apply, and then again review your organisational change and redundancy policies to ensure that they do reflect the new legislation when it does come out. Over to you, Maddie, for sick pay and time limits, and then we will just go on to I think the action bit, so we can sort of talk them through that.
Okay. So really quickly for SSP, the plan is for there to be a removal of the 3-day waiting period. So all eligible employees, regardless of earnings, will be entitled to SSP from day one, and that has been set at £118.75 or 80% of a normal weekly earnings. The aim of that, they hope, is to create less inequity, no presenteeism, reduce long-term sickness, increasing productivity. We need to have a think about the increased cost of that and the payroll and admin responsibilities to manage that, to ensure that it's paid and put in place any short-term sickness absence procedures. Again, you'll need to update any contracts and policies in relation to that. ET time limits, so we touched on this a little bit earlier, but the bill has been amended to include provision to extend time limits for the vast majority of tribunal claims from 3 to 6 months. So at the moment, you have to have submitted a claim within 3 months of an alleged act occurring or dismissal, etc. And that can be extended if there's a number of acts, but that now will be 6 months, which means that, well, the government believes it will ease pressure on tribunal services by allowing them to resolve the differences before resorting to formal litigation. Whether that will actually ease any pressure, I'm not sure. It might just mean that we see more claims because more claimants will be in time or will be persuaded to put that claim in because they've got more time to prepare it. And there probably will be a lot more claims in the tribunal. Whether the tribunal is prepared for that increase, we'll have to wait and see, because they are already struggling with quite a lot of backlog at the moment. But hopefully it will help and we can work to try and resolve differences before resorting to formal litigation. Marsha?
Thanks, Maddie. Fab. So just on the public sector outsourcing, essentially it's about making sure that people who are transferring, when there's contracting out of services So there's going to be an obligation that the new provider doesn't treat that person or those people less favourably than they were treated prior to any transfer. So just sort of looking at keeping terms favourable. We don't know when that part is going to come out, but the aim is going to be that we're going to try and prevent a two-tier workforce of some, people that have transferred, people that were already there, and having this two-tier workforce. And then it's sort of cheapy transfer type scenarios, what you're looking at, where people have transferred under a contract, and ensuring that you've done your due diligence before the people go over, or if they're coming in. And then the Fair Work Agency, just want to say quickly a bit about that, and then we'll go into the action.
Yeah, so it's nothing being set in stone. You'll see there that there's quite a lot which would put to be confirmed, but essentially what the plan is that there will be a new body to enforce workers' rights, inspect workplaces and bring civil proceedings on behalf of workers. So we don't know what their scope will be, but it can include a failure to keep adequate records of holiday pay for up to 6 years, compliance with holiday entitlement and national minimum wage. The powers will be including a power to investigate non-compliance, request a labour market enforcement undertaking, and apply to the court for an LME order as well. That's not likely to be put in place for some years yet. But in March 2025, in the amendments to the bill, we saw that they significantly increased the remit of the agency, including that they can recover enforcement costs from employers and bring tribunal claims on behalf of workers. So that's going to be quite interesting to see how that plays out, how that's going to be funded, and exactly how they work, and if they do support workers and employees.
Fab. So the next bit really is just sort of the call to action now in terms of what you do. There are some other slides on there which we won't have time to go over, but I'll send you a pack of the slides if there are any questions, then contact myself and Maddie. But in terms of what we do next, I think what we would say is have a look at some of our insights online that you can just click on those links for. Get up to speed on what's happening, stay updated as the situation unfolds. We're going to be doing updates frequently on this. Have a look at the Make Work Pay link on the government to see what is actually happening. And then the other thing is, if there are any consultations or calls for evidence, please do get involved, participate and have your say, and sort of get involved in your responses to these, because it does help and inform what happens next in terms of what the government decides to do. And then one of the key areas here is about risk. So have a look at your current practices, look at where your potential areas of risk are, and what the likely impact of that is to your staff, to the partners, to the workforce as a whole. What have you got in place already to mitigate against risk, and what should you be doing to mitigate that going forward? And then have a think about your working arrangements. So like I said, who are your staff? Are they self-employed? Are they contractors? Are they really, or are they employees? What do your contracts say? Training across the board in terms of all the elements that we've been discussing. Consult with your stakeholders. I think someone's put a comment in the chat about the ICB, and I haven't had a chance to respond to it, but yeah, have a think about who your stakeholders are, who is involved in this, and what do you need in terms of getting that consent or that authority to take the next step. So who, what does your arrangement say, or your contracting agreements say, about who is implemented changes and how. And then again, that advice and support, get your extra advice if you need to, and support on how to implement the changes is really key. We find that some organisations are finding it useful to set up a working group. I know it's difficult, everyone's really busy in your practices, but it might be worth having a few people who are basically in charge of making sure that this all flows smoothly for your workforce. And again, that depends on how big your practice is, but if you've got a huge practice, it may be good to set up that working group to prepare for the changes. So you're going to analyse and look at the results from all of the work that you've done, and then look at what action needs to be taken going forward. For example, like we were saying, identify where third parties have that opportunity to harass people. Taking all steps to ensure it doesn't happen. What does that look like for you as a practice? Amending your policies and your procedures to make sure that you're taking account of these reforms, and then look at your training needs. But again, for me, seeking to strengthen that relationship with your staff can really help in situations of change. If your staff are clear about where they're going, clear about how you're protecting them, they're more likely to engage with you, and they're less likely to bring agreements or a claim. and then make the necessary changes. We can help you with any or all of that, so definitely reach out to us if you need us to assist in any of that. And then just the last few slides there, the plan to make work pay. It's the phased delivery of this plan and the longer term changes for the plan. So I won't read all of those out. They're all set out there in terms of what the government is seeking to do, sort of as a summary, following on from the plan to make work pay. And then Maddie, neonatal care leave.
Yeah,
Really
so the right to statutory neonatal care leave is set out in the Neonatal Care Leave and Pay Act 2023, and that comes into force on the 6th of April, which is soon. The leave provides parents up to 12 weeks leave on top of any usual statutory maternity and shared parental leave if their baby requires neonatal care. It is a day one right and applies to parents of babies who are born after the 6th of April and are admitted into neonatal care for at least 7 consecutive days within 28 days of birth. And I've put here on the slides what neonatal care is defined as, so you will need to think about how the individual wanting that leave can evidence that their baby needs neonatal care. Parents will be able to take 1 week's leave for every week the baby spends in neonatal care, up to a maximum of 12 weeks. And again, it is on top of any other family leave entitlements. 2 categories of leave. Tier 1 is the period during which the child is receiving the care or during the week following the end of the care. And Tier 2 is any period after the end of Tier 1, but within 68 weeks of the child's birth. When can it be taken? So after the first 7 continuous days of care, but before the end of the 68 weeks, beginning with the date of birth, whilst the baby is receiving neonatal care or after other family leave has been taken, so after maternity leave, etc. Tier 1 can be taken in non-consecutive blocks of a minimum of 1 week whilst the baby receives the care, and Tier 2 must be taken in 1 continuous block, and the leave must be taken to care for the baby unless the child has died. This slide sets out the notice requirements that need to be given. I won't read those out because I know that we've run out of time, but they're on there and you need to make sure that your policies are in place and reflect that as well. But notice requirements can be waived by agreement if agreed. So for pay, statutory neonatal care leave pay, eligibility and rates are the same as maternity and paternity pay. It is paid by the employer. The statutory flat rate, it is the statutory flat rate or 90% of earnings if lower, and pay will be available to employees with 26 weeks continuous service who earn not less than the lower earnings limit. Next steps, make sure that you've got a policy in place that reflects the new legislative requirements. Look out for any guides that the government intends to publish before the 6th of April. ACAS are also going to publish some guides as well. And again, the rights and protections are the same as other types of leave, such as protection from detriment and dismissal, rights during absence and on return, and redundancy protection as well. I'll let Marcia talk about physician associates.
Just finally, just a really quick update. Well, I just wanted to really scope out really in terms of the physician associates issue. We keep hearing about this, and we're, like I said, we're doing an article on it, and I mean the issue is around that role and the fact that a number of physician associates have lost their job or are being treated unfairly and are going to be bringing claims against their practices. We think there's nearly 300 physician associates that have been potentially affected by the fact that there is this guidance around restrictive practices for the physician associates. And basically what's happening is these associates are bringing claims of potentially indirect discrimination because it's going to have an impact on people with protected characteristics, particularly women and ethnic minorities. So we understand that a number of them have already started bringing these claims, and that there may be various group actions against practices across the country, and it looks as if it's going to be worth sort of a real, practices who are faced with this, it's going to be really quite difficult for them. I just wanted to see whether anyone knows of anyone who is affected by this, or if it's an issue in your practices yet, just to see sort of the general consensus about it. The guidance, I should just say that the guidance from the BMA and the RGCP, it's guidance, it's not legally enforceable, but it basically limits the current practice of the physician associates stipulating who they can see, you know, what patients that they must not see. For example, patients not being triaged by a GP. It's really unclear about what their role is currently. The guidance is advisory, and we've always been clear that it's for employers to decide whether to follow the guidance. It's their responsibility to ensure that appropriate treatment has been used for handling those associates. So if anyone has an issue around that, or if anyone knows of anyone that's affected, then do please reach out and let us know. Our contact details are at the bottom. Or if you've got any concerns that you wanted to raise about that issue, let me know. Or if there are any other questions, let us know too.
Thank you, Marsha and Maddie, for joining us today. I think you've made something that seems very complicated a lot easier to follow and understand. So I appreciate your time that you've given to us, and we definitely welcome you back again in a few months to keep us in check with what we need to do regarding employment law changes. I can't see any questions in the chat at the moment, but we'll obviously, with your consent, share the slides, and hopefully any practices will come to you. And thank you very much for your time both today. Really appreciate it.
Thanks, Lucy. Would anyone mind sending us some feedback? If we send you the link for the feedback forms, that would be really helpful, just to see if there's anything else you want us to cover, or you know, what your experience of this training has been. That would be really useful. I'll get my PA to send it to you all.
Yeah, we'll send you a checklist that we've done for the employment rights bill as well.
Oh yeah,
which might be quite helpful
that would be really
send out and follow. Puts it into a 1 or 2 page document, which is much easier to follow.
Oh yeah, that would be really helpful. I think as you were talking, I was thinking, oh, there needs to be something out there about what do we actually do next. Yeah. Perfect.
Thank you
both.
Thanks everyone.
Thank
Take
you.
care.
Bye.
Bye. Bye.